Hello and welcome to The Big Fight. This week we finally saw the conclusion in the Supreme Court of what has been a really big fight. As Novartis has been filing for a patent on a particular drug, Supreme Court finally rejected that, and the repercussions of this have been extensive and global. There are some people who say this is going to enhance access to cheap, reasonably affordable drugs across the world. There are others who say this is a blow for pharmaceuticals and it's going to end innovation, especially in India. There's lots and lots to talk about and lots at stake, which is why we have some of the top experts who've really been following this extremely closely, and all of them virtually are there on this program. So the next 1 hour, we will really understand what was behind this verdict and what its implications possibly could be. Joining us right here in the studio, Pratibha Singh, who's a counsel for Cipla and Ranbaxy, two of the largest Indian generic manufacturers. Sandeep Kumar, who's had a really busy week. Sandeep, who's the head corporate and public affairs at Novartis. It's been, as I said, a difficult week for you, so I'm glad you could join us. Leena Megnani, who's advocate Doctors Without Borders. I'm going to use the English and not the French term for that particular organization, who's been arguing that it's going to enhance access to affordable drugs. Mihir Sharma, associate editor, Business Standard, doesn't feel that this was the right verdict and it could have very negative implications. Joining us from New York, Peter J. Pitts, who's the president at the Center for Medicine in the Public Interest, who's also a former associate commissioner at the US FDA. So, Mr. Pitts, it's really great to have you joining us. From Mumbai, DG Shah joins us, who's the Secretary General of the Indian Pharmaceutical Alliance. And from Kolkata, Shamnath Bashir, who was academic intervener amicus in the entire Novartis case. Can I first start with you, Sandeep? What this means for affordable medication, and the case itself, what it means for Novartis, what you're going to do next?
In terms of affordable medication, there is a clause in the Indian patent law which says that any generic which was launched before 2005 can continue to be sold in perpetuity. So all the generics that were Glivec generics were all launched prior to 2005. So even if the court had upheld the patent of Glivec, it is not as if those generics would have stopped selling the next day. That's one fact. The second fact which I would like to clarify, because again a lot of the reportage talked about how the price would have gone up to 1,20,000 if the judgment had supported the Novartis claim. We have since 2002, when we introduced Glivec into this country, have had a very robust patient assistance program where 95% of the patients get it free of cost, and the rest of the 5% get it in a very liberal co-pay program where they pay between 10 to 80 days in a whole year. So as a result, the kind of effective price of Glivec in this country has been around 5,000 rupees. So I think that's one fact that people should understand.
Okay, Leena, you were shaking your head violently while he was speaking. Why are you shaking?
No, I wasn't shaking my head violently. As donation programs goes, and Doctors Without Borders have been offered donations in the past. They come with a lot of conditions and riders. I just simply think that where was the donation program in 2004 when Novartis went to court to shut down the generics? Cipla, Hetero, Ranbaxy, they were all out of the market. There were stockouts, and cancer patients had to approach Lawyers Collective to get legal aid. There was no donation program, and I think the donation program was set up in response to the patent opposition that was filed by Cancer Patient Aid Association. So that's my immediate response. Number two is this: Doctors Without Borders put out many press briefings. We have been very clear that we never said imatinib would go out of production because of this decision, because we were clear there was an automatic licensing provision. We were saying the manner in which you interpret patentability has an impact across all other diseases and drugs on which patent
applications are pending. So the broader implication of this, you're saying, is as important as what happens in the Novartis case itself. Peter J. Pitts, let me come to you there in New York. What are the broader implications of this? Because I know you've come out and said this is going to have a really bad consequence, and especially for India. Would you like to elaborate?
This ruling really shows that India, at least from the Supreme Court's point of view, is against medical innovation. And the second point to what you've been discussing is the argument that this ruling will help to enhance access is phony and actually will hurt patients. Let me talk about that first. The WHO has a list of essential drugs. Almost all of them are off patent right now, or they've never been on patent, and yet those drugs are not being broadly available to the masses in India. from generic companies in India. So I don't really understand the concept of denying patents and providing access. They simply don't go from one to the other. In fact, Cipla, the company that was party to the Glivec patent suit, is being fined by the Indian government somewhere to the tune of $300 million for overcharging the Indian government for essential drugs. So again, I don't think that argument holds water at all. So that's the access piece. The second piece, I think,
Peter, can I just pause you for a minute to get a response from, we do have the Council for Cipla here. Let me just get a response to the access piece, and then I'll come to the broader issue. Pratibha, do you want to respond to what he just said?
According to me, the generics are doing their bit, and they supply 30% of the world with the cheapest medicines. Cipla supplied what was costing $10,000 to Africa for the AIDS program at $10. So I don't think anyone can make any allegation against Cipla or any of the generic medicines. Novartis' judgment has two main issues. One is what should the law in India be, and number two, whether the beta form is entitled to patents or not. The Supreme Court has held what the law in India should be, and this law, if I'm not wrong, is now going to be replicated in several countries of the world, because the world is fed up with repeated patents by the foreign companies on the same substance. Number two, I don't agree that this stifles innovation. Novartis does not deal with innovations, new molecules. This only deals with new forms of a known substance.